Hello, my name is Bill Ahern and I'm Principal of Family Capital Conservation Limited, my consultancy firm in Hong Kong. I've lived and worked in Hong Kong for more than 25 years, providing consultancy advice to families around the world on tax, succession and legacy. I'm a former branch chairman of the Hong Kong branch in Hong Kong. I sit on the STEP Worldwide Council and I am a member of various committees, both of Worldwide Council and of the local branch. Today I'm going to outline the major changes that have recently occurred to Hong Kong's trust law, which was first passed in 1934 and which was based on the English 1925 Act. Today I will deal with the various changes to these laws in the order that I'll shortly set out, and at the conclusion I'll make some remarks about what I think these changes will mean for the trust administration industry in Hong Kong in the future. The first significant change concerns a new statutory duty of care. The second contains provisions controlling the trustees' rights to restrict liability under the so-called exemption clauses, and also restricts the trustees' ability to indemnify itself in like provision. We will then deal with provisions concerning certain investment powers when they are reserved by the trustee to the settlor. I will then look at the validation of certain transfers of movable property to Hong Kong law trusts, also known as the forced heirship provisions. We'll then deal with the abolition of the rule against perpetuities and the rule against excessive accumulations of income. Next, we'll look at the new statutory court-free mechanism that allows beneficiaries in certain circumstances to change their trustees. And finally, we'll look at the improved default powers of trustees to delegate prescribed functions to agents, custodians and nominees. The new statutory duty of care provisions. These essentially follow the English model, and they set different standards for professional and non-professional trustees. As far as professional trustees are concerned, there are essentially two tests. One, an objective test, and two, a subjective test to view the actions of the trustee to see whether they are in breach of the statutory duty. As far as non-professional trustees are concerned, we are there only concerned with an objective test as to what a reasonable person might expect the trustee to do in the circumstances. The new statutory duty of care applies both to new trusts and to existing trusts. And this happens unless the new duty is specifically excluded from existing trusts or new trusts. And there is a mechanism which prescribes how to go about excluding those new statutory duty of care provisions. In essence, the new statutory duty of care provides much greater certainty as to what is expected of both professional and non-professional trustees, and does, in my opinion, not actually result in a significant higher standard of care for trustees, but a more certain one. I now turn to provisions controlling the trustee's right to restrict liability under so-called exoneration clauses. Previously in Hong Kong, we relied only on the common law tests which governed this area, so this is a first time in Hong Kong that we have provided a statutory control of these provisions. The essence of the provisions is, in fact, to go further than the rule set down in Armitage and Nurse, and the provisions strike down exoneration clauses which seek to restrict a trustee's liability for breach of trust arising from gross negligence, fraud or willful misconduct. The upshot of these provisions is, I think, to give both beneficiaries and trustees greater certainty in their relationship. When these changes were first suggested, there was some unfavourable reaction from trustees in Hong Kong. However, the government in Hong Kong insisted that the amendments to the trustee ordinance needed to have balance of rights and responsibilities between trustees and beneficiaries. And I think that they will, in the end, be accepted by both trustees and beneficiaries around the world to provide a much more certain regulation of the relationship between trustees and beneficiaries. Let's now deal with the new provisions which provide for the validation of powers in trustees which are reserved to settlors, the so-called settlor reservation of power provisions. These changes are potentially the most interesting in the new law. The provisions clear up the previous uncertainty about whether provisions in trust deeds which reserved to settlors investment functions might invalidate the trust. The statutory provisions make it clear that where investment functions and investment management functions are delegated by a trust deed to a settlor, that of itself cannot invalidate the trust. But interestingly, the provisions go further. What they say is this: if a trustee acts in accordance with the direction from a settlor who has had reserved to him the investment powers, there is no breach of trust. This is very significant because we are not here talking about an exoneration from liability. We are talking about a statutory provision which says there is no breach of trust. This provision is, to my knowledge, unique in the common law world, and we will have to see what limitations on the provision arise out of academic writings and common law decisions going forward. I now turn to provisions concerning the validation of certain transfers of movable property to Hong Kong law trusts, or as they are known colloquially as the forced heirship provisions. The provisions provide that foreign succession laws do not affect the validity of transfers of movable property to certain Hong Kong trusts. Those trusts are trusts which are governed by Hong Kong law and have a trustee which is a resident of Hong Kong, if an individual, and if the trustee is a corporation, if that trustee is either incorporated in Hong Kong or centrally managed and controlled in Hong Kong. After much lobbying and much discussion and hand-wringing in the professions and in the government, Hong Kong has now moved to abolish the rule against perpetuities and the rule against excessive accumulations of income. This means that from December 1, 2013, it is possible to create perpetual trusts in Hong Kong. The change was made because the industry thought that this would attract settlors from around the world to Hong Kong, and we will see in the future the extent to which this change achieves that goal. I now deal with the new statutory provision which allows beneficiaries to remove trustees without going to court. The rule in Saunders and Vautier is still very much alive in Hong Kong, but now beneficiaries can take control of their trusts by choosing to sack and appoint new trustees without going to court, provided they comply with the mechanisms in the law to allow for the removal and appointment of trustees in normal circumstances, and also where those trustees are incapacitated for any reason. The final provision that I'd like to deal with is the provisions which improve the default powers of trustees to delegate essentially investment functions to nominees, custodians, and agents. The upshot of the provisions is to greatly increase these powers, but to put conditions upon them which are set out extensively in the new law. These provisions have less relevance where trust instruments provide in them significant powers of delegation, but they will be very important in certain situations, for example, in testamentary estates where often the trustees' powers to delegate are not significantly set out in the will. There is no doubt that the changes I have described significantly improve the trust law in Hong Kong. And whilst the changes do not go as far as many other centres have, where trust law has become something akin to all things to all men, I think the changes strike a sensible balance between making trusts more adaptable to modern business needs, yet not robbing them of the central characteristics of a relationship built around property and subject to the principles of dual ownership and subject also to obligations to beneficiaries based upon genuine notions of fiduciary duty. It is now hoped that when settlors and their advisors survey the world for trust laws suitable to their own structures, that they will look hard now at what Hong Kong has in addition to its other jurisdictional strengths. Thank you.